So we'll go ahead and get started. Hi, everyone. I'm Erin Wilson. I am on the executive board of Decalogue Society and part of the Women's Committee as well. I want to welcome everyone for our family law, our annual family law hot topics. I organized this in connection with Judge Rosen, who is finishing up a court call right now and will be joining us soon. But we have two amazing attorneys to speak to us today on hot topics in assisted reproductive technology. And then we're going to hear from a panel of our judges in family law to talk about how these play out in the courtroom. So first we have Dina Levy. Dina is a solo practitioner at Levy Law Solutions in Skokie. She went to University of Wisconsin-Madison for undergrad and received her JD from Columbus School of Law. She's a solo practitioner practicing exclusively in assisted reproductive technology for 15 years, and her law firm represents clients in egg donation, sperm donation, embryo donation, and surrogacy agreements. She's on the board of the legal professional group of the American Society of Reproductive Medicine, a board member of the Women's Philanthropy Board of JUF, and a board member of the Sarnoff Center for Jewish Genetics. She's also a member of the ABA Family Law Section for Assisted Reproductive Technologies, the Society for Ethics in Egg Donation and Surrogacy, the Decalogue Society, ISBA, and the CBA. And she's also a member of the Illinois Bar, the Northern District of Illinois, and the United States Supreme Court. And Ms. Levy has given presentations on various topics related to reproductive law. Next, we have Rebecca Melzer, who has been practicing in family law since 2007. The majority of Rebecca's practice is divorce, prenuptial agreements, and family law building, including adoptions, embryo disputes, and guidance. She practices litigation, appellate work, and is a collaborative attorney in Cook County, DuPage, and Lake County. Her firm is an all-female firm consisting of herself and 4 other attorneys. She's on the executive board of Shalva, which is a Jewish domestic abuse agency that provides counseling and legal services and community education to women and individuals identifying as women. She started her career as a law clerk to the former presiding judge of domestic relations, Judge Jacobian, and has worked at a larger law firm, managed a smaller law firm, and then went on her own in 2017. She has 3 children and lives in Wilmette. So those are our 2 attorney panelists, which are really good, diverse, because one is more on the contract side and the other on the litigation side. So they bring a wealth of knowledge. I also want to give a major plug to Molly Carmody, who helped to prepare the PowerPoint today, which looks fantastic and is very informative. We'll then hear from our judicial panel, consisting of Judge Rosenberg and Judge Weber. So they both sit in the Domestic Relations Division in the Circuit Court of Cook County, handling disputes pertaining to custody, visitation, property division, maintenance, child support, and domestic violence. Judge Rosenberg presides over an individual calendar and previously presided over a court call at the Domestic Violence Courthouse and in traffic court. Prior to becoming a judge, Judge Rosenberg was a chief attorney at the Chicago Transit Authority, defending the CTA in wrongful death and catastrophic injury cases. She's a board member of the Decalogue Society of Lawyers and a member of the Jewish Judges Association and Illinois Judges Association. Judge Weber currently presides over a team calendar and previously presided over traffic court, as well as misdemeanor cases and preliminary hearings in the First Municipal Division. Prior to being elected to the bench, Judge Weber served as an assistant Cook County public defender for almost 16 years. She's a member of Jewish Judges Association and the Decalogue Society of Lawyers. So thank you, judges, for giving us your time and your wisdom, and I will turn it over to the lawyers. Thank you.
Okay, thank you. I'm Dina Levy, and I am going to start us off this morning. And I'm just going to delve right in. According to the World Health Organization, currently 1 in 6 people of reproductive age are impacted by infertility globally. In the US, approximately 1 in 8 couples are affected by infertility, and that's about 6.7 million people each year who are having trouble conceiving. When we break down those US numbers, we can see that according to the American Society for Reproductive Medicine, known as ASRM, approximately 1/3 of infertility is attributed to the female partner, 1/3 is attributed to the male partner, and 1/3 is caused by a combination of problems in both partners. or it's considered unexplained. Another disheartening statistic is that according to the National Women's Resource Center, a couple aged 29 through 33 with a normal functioning reproductive system only has a 20 to 25% chance of conceiving each month. And after 6 months of trying, 60% of couples will conceive without medical assistance. Next slide, please. So we may ask, what exactly is infertility? According to the ASRM, infertility is considered a disease, condition, or status characterized by any of the following: either the inability to achieve a successful pregnancy based on a patient's medical, sexual, and reproductive history, age, physical findings, a diagnostic testing, or any combination of these factors, or the need for medical intervention, including but not limited to the use of donor gametes or donor embryos to achieve a successful pregnancy, either as an individual or with a partner, and in patients having regular unprotected intercourse and without any known problems of either partner that could impair their reproductive function. An evaluation would then be done at 12 months if the female partner is under 35, or at 6 months when the female partner is over 35 or 35. When a person receives a diagnosis of infertility, it often creates one of the most stressful life crises in that person or couple's history. And the long-term inability to conceive a child can create deep feelings of loss that are coupled with a multitude of medical decisions and uncertainties that come with infertility. It can create a lot of emotional upheaval for most couples. And most couples also, unfortunately, experience anxiety and depression and feelings of being a complete and utter lack of control in their lives. And that can lead to isolation, that they feel that they are the only people who are going through this. Next slide, please. So let's do infertility by the numbers. Approximately 44% of women with infertility have sought medical assistance. And from those, about 65% give birth. About 85 to 90% of infertility cases are treated with drug therapy or surgical procedures. And then there's about 33%, like 3% that needs in vitro fertilization, otherwise known as IVF. If we were to talk to a group of about 100 people born in the US, chances are 2 of them were born as a result of using IVF. And in many ways, IVF is actually one of the great triumphs of modern medicine. One of the things that's helpful to know is just how common it really is. There are at least 2% of births in the US that are coming from IVF, and worldwide, there's over 8 million babies that have been born with that technology. Now, I'd like to give you just a tiny genetics lesson so we can have a more fruitful discussion when we get to talking about the contracts involving embryos. Women who are born, when you're born as a woman, you're born with all the follicles you're ever going to have. So the amount of follicles are gradually going to be used up over time. As a woman's ovarian reserve declines, the follicles are less sensitive to stimulation, so they require more stimulation to mature and ovulate. So a woman can use them. And women with poor ovarian reserve have, understandably, a lower chance of becoming pregnant than women with normal ovarian reserve. Now, if we take the topic off of the woman, when a couple is having trouble having a baby, there's about a 50-50 chance that it's the man who is having the problem. And that might be because he's producing too few sperm to fertilize the egg. The sperm may not be shaped properly, or they're not moving the way they should. There might be a blockage in the man's reproductive tract that keeps the sperm from getting out, or a couple may have alternative reasons for needing IVF, such as same-sex couples or single parents by choice. So what exactly is assisted reproductive technology, otherwise known as ART? According to the Society for Assisted Reproductive Technology, known as SART, ART includes IVF, embryo transfer, gamete interfallopian transfer, zygote interfallopian transfer, and frozen embryo transfer. And these different techniques are going to be applied to egg donation and surrogates. About 99% of ART cycles are IVF cycles, and usually ART interventions are going to be recommended when less invasive treatments like intrauterine insemination are not successful, or there's severe, male factor infertility, severe endometriosis, or tubal obstructions. So you may wonder, what is IVF and does it even work? And the answer is yes, it definitely works. The first birth resulting from IVF was actually in 1978 in England, and IVF was introduced into this country in 1981. As of 15 years ago, over 500,000 babies have been born with IVF, just to give you an idea of the scope. And that was 15 years ago. So it's even more so today. What IVF is essentially is a technique where women's eggs and a man's sperm are combined in a special laboratory to create an embryo. And depending on the diagnosis and the age of the woman, an embryo is either transferred into the woman's uterus through her cervix to create a more likelihood of pregnancy, or IVF is used for heterosexual couples or same-sex couples if they are experiencing infertility, and women or men who are single parents by choice. And the technology has also allowed couples who carry genetic diseases to test their embryos and only transfer those that wouldn't be affected by the diseases. So to accomplish this, patients undergo 8 to 10 days of fertility injections with hormones that help their eggs mature. And after fertilization, doctors watch those embryos as they develop. And according to Dr. Eve Feinberg of Northwestern, if 10 eggs are exposed to sperm, about 7 of them are going to fertilize. And of those 7, only 25 to 50% will grow in a laboratory long enough to be considered a mature embryo called a blastocyst. Just to give you a scope of the numbers that we're talking about. From there, depending on the age of the patient, the blastocyst has between a 10 to 60% likelihood of even becoming a baby. So you may now be wondering, why would you freeze embryos? Freezing embryos is helpful for the genetic test, or if patients don't intend to get pregnant right away. Typically, there's a higher success rate when fertilized embryos are frozen and not just freezing the eggs. Another reason some patients may choose to freeze embryos is for medical reasons, such as chemotherapy, because the cancer treatment may damage their ovaries. Or it can be because they're not at the right stage of their life to conceive, but they do want to preserve a better chance for pregnancy in the future. So if one cycle of IVF can result in multiple embryos, freezing those embryos can keep those options open for future use. And in the past, it was more common to implant multiple embryos with each try. Now, with the ability to freeze embryos, doctors typically implant one embryo at a time, which is much safer for the patient and for the future baby. And I also just want to let you know, not all embryos are the same quality. So a person trying to have a baby wants to make sure they have a nice grouping of good quality embryos to use. So why not just fertilize one egg at a time? Science has borne out that one single fertilized egg is not enough to create a baby. And furthermore, if patients want, let's say, 2 or 3 children, they may need between 2 or 4 embryos for each. So now that you have all these embryos stored in the freezer, what does that mean for us? Typically, when patients store embryos, there are embryo storage fees that they're going to incur. And those can be quarterly fees of $150 to $300 or several $1,000s a year. And when a person's embryos are stored, they usually have 5 disposition options when it comes to their remaining frozen embryos. Next slide, please. So what options exist for those stored embryos? Well, typically there are 5 options for IVF patients to consider when it comes to the remaining frozen embryos. First, they can store them. They continue to store them indefinitely at their clinic or another cryopreservation center. They'll continue to pay those quarterly or annual storage fees. And that way they'll preserve an option for future family growth, or they may need more time to make other arrangements and figure out what they really want down the line. A second option is called compassionate transfer. And what that means is that your medical team is going to work with that person to thaw and transfer the embryos at a time when a pregnancy is least likely to occur. That decision does carry its own emotional toll, and not all clinics are willing to perform that. And the clinics that are willing to perform that generally charge a fee for that. A person wanting to do that would also need to make sure that they were comfortable with that, because the emotional toll that it can take. A third option is disposition. So if a person decides their family is complete, they no longer want to use their remaining embryos, they can ask their clinic or their storage facility to destroy the remaining embryos. Generally, that person would need to sign several consent forms, other documents affirming their wish that those embryos are destroyed. And there may also be a cost associated with that. But after that point, they're not going to have to pay any continuing storage fees. They will be complete with that. A fourth option is donation to research. So someone can decide to donate their embryos to their own clinic or another clinic or a research center. And in that scenario, the research could include all kinds of research, including stem cell research. If you use donated embryos, or donated eggs or donated sperm to create those embryos, then you're going to need to ensure that your egg donation contract or sperm donation contract allows you to donate your embryos to medical research, or if there are limitations on that disposition option. That's also going to be the case involving the fifth option of embryo donation to other people. In recent years, embryo donation has become more popular for people to either start their families or grow their families. And in that situation, a person would donate their embryos to someone else to use in an IVF cycle. Typically, embryo donors want to pass along their good fortune in being able to create a family and kind of pay it forward, so to speak. So they'll donate their extra embryos to others. And that can be a less expensive option for people trying to create a family, because the embryos are ready and they would not pay a fee to receive them. They would only pay for storage fees to store them and the medical expenses. And a lot of people donating their embryos to others feel more comfortable knowing that their embryos are not being destroyed and they're not sitting in a freezer for an unlimited number of years, that they're actually being used to help someone. And some people who are recipients of donated embryos also feel more comfortable knowing that they're not contributing to the growing number of unused embryos. They're using material that's already been created. If someone does choose to donate their embryos in this manner or accept donated embryos, everyone would just need to be comfortable with the fact that the recipients are not going to be genetically related to the child that they're creating, or that they're carrying, rather. And the donors, would also have to be comfortable with the fact that their child or children would have a full genetic sibling somewhere else in the world that they wouldn't necessarily know about. So if intended parents decide this is a good option, then, and the recipients decide the same, they would enter into what's called an embryo donation agreement, which is a contract between the donors and the recipient. And that is going to spell out everybody's rights and responsibilities in the arrangement, including whether the intended parents are going to be taking over those storage costs for the embryos, and if they're going to need to pay for shipping fees if the embryos are located in a different state or in a different clinic, as well as medical testing for the donors if that were necessary. There's also going to be attorneys on both sides. So in this scenario, the recipient would have their own attorney, intended parents would have a different attorney, and the intended parents would typically pay for both attorneys' fees. So those would be additional costs that recipient, as intended parents, would incur. Now, once everyone agrees on the terms of this agreement, it's signed, a letter is then sent to the clinic, letting them know there's an embryo donation agreement in place, and the embryos will then be relabeled to reflect the new ownership for that person to use. Specifically, under Illinois law and the agreement, the intended parents would then be considered the legal parents of the child coming out of this donation. The donor would give up all rights and responsibilities to the resulting child, and the child would not be considered the legal child or an heir of the donor if the donor or donors were to pass away. So the donors would not have any parental, custodial, visitation, financial, legal rights to that child, and the intended parents' names would be put directly on the birth certificate at the time of the birth. Next slide, please. Now, this is all on this slide. It covers the Illinois Parentage Act of 2015, and that's what's going to govern embryo donation in this scenario. So I'll let you just peruse that. And next slide, please. Generally, in an embryo donation agreement, there's going to be a provision that holds that the donor is considered harmless from any damages resulting from the embryo donation, unless in the event of the donor's intentional misrepresentation, or if the donor intentionally left out material involving her health history or his health history, depending on if it's a sperm or an egg donor agreement. So in circling back to the intended parents and their disposition options regarding extra embryos, if intended parents need to use either donated eggs or donated sperm to create their embryos, then they're going to enter into an egg donation agreement or a sperm donation agreement with their recipients, depending on the situation and what material is needed to be donated. Next slide, please. However, in either of these scenarios, there's typically going to be a provision included in those contracts addressing what the intended parents can do with their extra embryos, whether they can donate them to medical research, donate them to other people, or freeze them, destroy them. All that would be articulated in the contract. And since the intended parents would have a legal contract spelling out their wishes, this would also create an opportunity to include language regarding a situation where the intended parents break up or separate or divorce. And in those situations, what would happen to those unused embryos? A provision can be included in the legal contracts or as an exhibit to the contract addressing this type of situation, so there's a clear roadmap for the future in the event the situation happened. Next slide, please. Alternatively, if there's a situation where this is not addressed in an egg donor or sperm donor agreement, then usually the contract is just going to say, in the event of a dispute, this would go according to the parties' clinic consent forms or mediation or court. And that effectively just kicks the can down the road and does not make a decision. However, surprisingly, I would say about 75% at least of the time, when I review egg donor or sperm donor agreements with intended parents and I raise the what if topic with them, they quickly shut me down and they do not want a provision addressing this situation in their legal contracts. Generally, I'll go through the entire spiel with my clients discussing the importance of having a written document, with a roadmap and for unforeseen problems, unpleasant events that could occur down the road in the future. And yet, at the time I'm discussing this with my clients, they're coming from a place where they've already been through so much and so many pregnancy failures, and they've spent a lot of time and a lot of money getting to where we are at this point, that they're now hopeful again, and the option of using a donor is now going to work for them. They're finally going to be able to create their family, and they aren't going to have any additional setbacks. So many of these intended parents don't even want to entertain the notion that their relationship may fall apart at some point. They just will not go there emotionally. Their feeling is that if this happens, they're comfortable taking their chances that they'd be fighting with their partner over the embryos in court, and they'll be spending a lot of money on that. And I would say, surprisingly, a lot of these parents also feel that if that happened, their life's imploded, and they don't care now that they are going to court to fight over these embryos. So that sort of creates an ethical dilemma as an attorney as to, does the attorney then force their will over their clients to include language that the clients don't want in a contract? And I'll just end my remarks with the Alabama case. Patients oftentimes turn to the courts when fertility treatments go wrong, leaving the judges to decide like what clinics owe in certain situations, what the emotional, physical, financial losses are. And lawsuits against clinics typically claim that there's negligent behavior that led to the embryo destruction. But in this situation, the Alabama Center for Reproductive Medicine, the couples who lost their embryos took a different approach. It was actually a novel approach, arguing that the accident resulted in wrongful death under their state law, and that the embryos were cryopreserved embryonic human beings. The storage room should therefore be viewed as a daycare with state regulation, required to be secured and closely guarded, because small children, including embryos, can't protect themselves. And the state Supreme Court of Alabama agreed. And the official name of that case is LePage versus Center for Reproductive Medicine, otherwise known as the Alabama case. And that held that these extrauterine embryos are considered children for purposes of Alabama's Wrongful Death of a Minor Act, and that the parents of the deceased child can recover punitive damages for the death of their child. So that decision was ruled on February 16th, and it was a 7-2 ruling. And the embryos that were created by IVF weren't now just considered a potential person, they were considered an actual person. Therefore, Alabama became the first state in the country to decide that frozen embryos should be considered unborn children for the purposes of a civil wrongful death act. So now other states might see this ruling as a path to recognize frozen embryos as legal children for purposes of wrongful death or under another state law. And the plaintiffs in this case sued, alleging many things, that there was negligence, breach of contract, but then they threw in the novel approach, and that's what the court went with. And the court based this on a 2018 ballot measure that they had that recognized fetuses as persons under their state law. And that was the novel situation. There was also a concurring opinion by the Chief Justice Parker in that case, suggesting that divine law, which he claimed had been embraced by the people of Alabama, supported the court's conclusion that human life cannot be wrongfully destroyed without incurring the wrath of the holy God. So what resulted in Alabama after this ruling was, within a few days, University of Alabama in Birmingham and later 2 other clinics announced that they were pausing all IVF treatment aside from egg retrievals while they figured out the liability. And one of the major embryo shipping companies, Cryoport, also said at that point that they would be pausing their business in Alabama until they did further evaluation. So the ruling effectively served to significantly limit fertility treatment for patients in that state. Then in the middle of last month, lawmakers in Alabama passed a law restarting IVF services across the state and granting protection to doctors that perform those services. However, there are many limitations to that new state law, including that the law does not adequately address what happens to embryos that are currently stored across the state? Do you have all those disposition options we talked about earlier available to you? And I will end with just putting a little Jewish twist on this. The Jewish tradition does not consider an embryo as having the same legal status as a person. And according to the National Council of Jewish Women, Jews in the United States, of course, disproportionately rely on IVF, with about 17% of Jewish women using fertility treatments to get pregnant compared to the general population. So there are many trickle-down effects, and I will now turn it over to Rebecca.
Thanks, Dina. That was really informative. I'm going to turn to a little bit about how we dispose of frozen embryos. So Dina gave us a really great backup and understanding about how they're created, about donor agreement contracts when we have two people getting embryos, but I'm going to talk about different forms that are signed and how we can dispose of embryos. So Molly, you can go to the next slide. I'm just going to talk quickly though about slide 6, that there are a lot of different ways and contracts that can be signed to dispose of embryos. One can be the medical consent forms that are signed at a doctor's office when two parties go to create embryos going through IVF. And I'll go through that in a moment. Another one can be addressing them in prenuptial agreement. So if we have two people who are married, I think it is imperative to have a discussion and actually start the conversation about what might happen with embryos and what to do in the event of death or divorce. You can contract for that, and there hasn't been an Illinois appellate case yet on that enforceability, but there's certainly been other litigation on that. You also should provide it in a marital settlement agreement. For anybody who is practicing family law, on my intake, I always ask people if there are any frozen eggs that are not inseminated or embryos that are. And so I think it's an important consideration and something that you don't want to miss. And another area is in any estate planning documents, in a will, in a trust, to consider how to dispose of them in the event of death. So what you're seeing right now on the slide is one example of a medical consent. And I think Dina brought up something that's really imperative, is that when two individuals, and I'll speak of a male and female, however, that doesn't, I'm just making that assumption in this conversation, go to get IVF treatment, they are in a very emotional state. It's a very difficult life stage, and not necessarily thinking when you're at a doctor's office that you're signing a medical consent form for treatment that can be a binding, enforceable contract later in the event two people disagree about how to dispose of an embryo. And so when you go through an IVF cycle, when you're at a medical provider's office, there's multiple stages. Oftentimes you start with this follicle stimulation, and then you have the retrieval. At the retrieval stage is oftentimes where this medical consent form is signed. What's interesting is in Illinois, there's absolutely no legislation about what is required to be in a medical consent form. So I have 3 examples on the slides for you of 3 different medical consent forms, and each one can be different. So there's not consistency when an individual goes to a fertility center about what they're signing. So during that retrieval stage, right, the woman has been, it has had medicine, it has had their follicles stimulated, and they're looking at retrieval and then likely insemination at the same point and day of retrieval. And then any additional embryos might be fertilized that same day or might be frozen. They all might be frozen. It's, a to be determined if there's genetic testing or other things. And at that retrieval is where these forms are signed. There's no lawyers present. Typically, you're in a small side room in a doctor's office. There is often a medical provider, like a nurse or someone else there, who may be a notary to sign them. And sometimes they're provided the same day. I've had clients get them the same day, a package of 40 pages of documents where they have to read and sign off. And they really aren't giving the thought and consideration that you think that you do on when you're signing a consent of what happens in the event that you break up or other circumstances, what to do with the embryos. Most people just want to create their embryos. They're super excited. They're ready to get through the process, and they're not thinking about what's happening. I'll discuss it later. It's not on a slide, but in Safransky, there's 2 Safransky cases. It's the seminal case before CATSIP that went up on appeal twice. That form in Safransky was from Northwestern's clinic. You think a great clinic, they understand all circumstances. And in that situation, the parties were unmarried, but they did sign a medical consent form, along with many other forms in connection with the retrieval and fertilization of the embryos. And at that time, that consent identified only 3 situations. Northwestern, I think, has since changed their forms, But at that time, they dealt with situations of disposing embryos in divorce or dissolution, in the death or incapacitation of one or both of the parties. Well, in that situation, the parties went and created embryos and they weren't married. And so the medical consent form that they signed at the medical provider's office didn't apply to their situation. So again, it's not something that people are even necessarily thinking about of the impact of that. This slide, slide 9, it's from a large medical fertility treatment center in Chicago. And this medical consent form discusses being signed by both parties. It's a portion of approximately a 40-page contract that I was involved with litigation on about enforcing this disposition. And what's interesting in this is that you have to read every single word in litigation if you're seeking to enforce the terms or not enforce the terms of a contract. In this document, the fertility clinic kept referencing your IVF treatment. Well, there was no definition in the contract of what IVF treatment is. And in this, we look to the language on the fertility company's website, in other forms, and they were really talking about one IVF cycle. So interestingly enough, Dina talked about how often IVF occurs. It's not just one cycle. Oftentimes women can go through multiple cycles in order to get egg retrieval. Sometimes the eggs are not in a place that they, when once inseminated, they keep and they freeze them after a couple days of growing them. They're not graded at a level where they would keep them. And so oftentimes women go through multiple retrievals and multiple cycles. And in the case I was involved in, there was only a disposition signed one time. Notably, if you are in litigation, you can subpoena the fertility center and see what kind of forms they have. In this situation, we pulled back and we saw, okay, well, the company actually had certain requirements that they sign a form with every cycle. And it wasn't signed at the cycle that the embryos were created. So in a situation where two people could, on divorce or dissolution of a relationship, you can see award it to the patient, award it to the other person, donate, destroy, or do another thing. It wasn't enforceable because it wasn't applicable to the round of IVF cycle that created the embryos. This is something that when individuals are going through IVF, they don't think about. They sign these documents, they put them away. Oftentimes, while they're given a copy, they don't even keep them because their mindset is not, what happens if we break up? Their mindset is, we need to seek, we want to seek and have a baby. And I think it's really remiss for medical clinics not to give guidance and say, go to a lawyer, go to someone like Dina and have someone review a contract, because what they're signing can and will be enforceable. Will you switch to the next page, Molly? Thank you. Here's another medical consent form. As you can see, it looks very different. The content is also very different. So in this document, it notes that they will store the embryos for up to 5 years. And where there's not clear evidence, there may be other dispositional choices. So what's sort of interesting is that each fertility clinic not only has their own individual consent forms, but their own pattern and practice and own ways in how they enforce it. So I also find it sort of interesting that two individuals are coming to a medical provider asking for consent for treatment. I don't know what the consideration is, right? I guess the consideration is creating the embryos, but courts have found these to be not just binding contracts between the medical provider and the parties, but between the parties. So it's interesting to see. This doesn't say what to do after every year. So this contract that people may sign say they're required to renew their consent annually. So two people may go to a medical provider. They may say that in the event of divorce, we want to discard them. But this contract hasn't been renewed and signed annually. And in the event of a divorce, I certainly think there could be an argument made that if it wasn't signed annually, people's intent changes. And maybe then we have to litigate it and make a determination of who is awarded the embryos. Page 11 is, again, another example of all of these are recent medical consent forms from providers. Again, it says if the embryo disposition is unclear and it cannot be resolved or is in dispute, they can take its sole discretion and refrain from taking any action until the court is involved. And I think that you're seeing many more instances where courts are getting involved in how do we allocate embryos when two parties, whether or not they're married or not, have created embryos and they don't agree about how to dispose of them. The next page, Molly. Thank you. So I mentioned in prenuptial agreements, I both draft them and review ones that are drafted. And example one is one that we did not draft. But if you see this, it said the parties agree that no later than 30 days, they'll take any action to destroy any and all embryos. What's interesting with this is that's interesting in a prenup. You have that before embryos may be created, but what happens if embryos are created later? Will a court determine that a contract that's signed at a medical center supersedes their initial prenuptial agreement? So I thought that this language in example one was insufficient and could leave open an opportunity for litigation on what to do in the event of other documents being signed after a prenuptial agreement. Certainly think that given the fact that the appellate court has determined that the medical consent forms are contracts, that you could argue that a medical consent form after a prenuptial agreement could be considered a postnuptial agreement, and example one language be unenforceable. Paragraph 2, I wanted to give some real examples, is another example of some language that I think would be more guidance to a court, and that it has the idea that they're going to undergo in vitro fertilization. We've recognized that the parties have considered this, that they agree about how to use them, and they agree that any document signed later will either supersede or not supersede this agreement, so that we have an understanding and intention of what is signed at the fertility center or other location being enforceable or not enforceable, and preemptively agreeing about how to manage this. And next slide, Molly. Thank you. I want to address the two relevant cases in Illinois that really impact the disposition of frozen embryos. We think that people might agree, but unfortunately, in many situations, people don't. The first one was Safransky. The cited case is the second time it was up. The case was up at appeal twice. The first case was, I believe, in 2013. And in this case, the court was looking at how to determine the disposition of frozen embryos. The woman in the case, Carla, was going through a cancer treatment and was not married, but was in a relationship with her boyfriend Jacob. And they, during a quick phone call, she and him agreed that they would inseminate embryos, that she was going to go through IVF, and she asked to donate the sperm. He was at work. He stepped out of his job. He took the phone call and he went back in. And they went to a fertility clinic, embryos were created, and her eggs were inseminated with his sperm. They did also, at the clinic, sign a document, as I mentioned earlier, the Northwestern document, however, did not address what would happen in the event an unmarried couple split up. It only had an assumption of what would happen as a married couple either donating, discarding, or granting the authorization over the embryo to one of the couples. So the court determined that that document, the medical contract that they signed at the fertility center, did not apply. Interestingly enough, even though Illinois does follow the contractual basis in determining if there's a valid and enforceable contract, enforcing that with what to do with the embryos, the appellate court in 2015 also looked at the balancing of the interest factors. I think the appellate court, I don't know why, but my guess was in the event for some reason it was taken up to the Supreme Court and reviewed, maybe they wanted to also analyze the secondary balancing of factors. And in that case, even reviewing it, the court said Carla would still get the embryos, that she was going through fertility treatment, and she had no other way to create a biological child of her own. And that there were text messages and there were other indications that, they intended for her to have the embryos at a later date. Interestingly, after the medical consent forms were signed in Safransky, the parties did seek legal guidance from an attorney. They never signed any agreements through that attorney, but they did discuss whether or not there should be a co-parenting agreement or a sperm donation agreement, and nothing was signed. So it just goes to speak that either life gets busy, it gets so overwhelming, and it just never happened. But in that case, he testified he didn't want to be forced to procreate, and it would impact his life, his love life, his ability to move on with his life if he had a baby, and the court just didn't care and awarded the embryos to Carla. More recently, there was an Illinois case, the second Illinois case on that. You can go to the next one, Molly. Katzip really discusses what factors or some of the factors we use in balancing the interest, because how do you determine what to do? In that case, it's interesting. It was a Jewish couple. They tried to seek enforcement as a declaratory judgment as a prenuptial agreement. They're ketubah. They were the party seeking that was unsuccessful. But in that case, they already had one child together, which I thought was impactful. And I personally was surprised that the appellate court didn't consider it as strongly as I thought that they would. The parties had created embryos and used a surrogate to have a baby and had one live child at the time. The court in that case looked to a Colorado case, a seminal Colorado case, the Rooks case, to determine what factors in deciding who should receive the embryo. And the court was really clear. It was not an exclusive list of factors. So I think in any litigation, it's so fact specific. It's really important to understand the history of your client's situation on either side to try to make the best argument for your client on whether or not they should or should not receive the embryos. One of the factors the court was looking at was the intended use of the party seeking to preserve the embryos, with placing greater weight on the person seeking to become a genetic parent versus donating it to another couple. Interestingly enough, the case did not discuss at all destroying the embryo or donating the embryo to research, some other options that Dina spoke about. The court also looked at the inability physically for a person to carry the child or have a child through other means. And they also looked at what are the original reasons to pursue IVF. For example, preserving fertility in a medical treatment like what happened in Safransky. And they also looked at the hardship to the parent to avoid becoming a genetic parent, as well as if there was a bad faith attempt to use the embryos as leverage in a divorce. In the trial, court in Katzep actually awarded the embryos to the dad, and then on appeal awarded them to the mom. What was interesting about this was there was no contract. There was no clarity on what to do. And looking through these factors, I personally found it interesting because there was already a child born. I thought that would actually support more awarding the embryos to the father because they already had a child together. And Safransky really, in the balancing factors, looked to the fact that she could not have any biological child without using the embryos. And in this case, that she did. I also thought it was interesting because of the hardship to the person seeking to avoid to become a parent. If that person did not want to become a father to another child, he's already seeing his first child. It's very hard to avoid a second child. And so there were certainly impacts in that case. In litigation, you can go on to the next one, Molly. I think we have to think about what could be used and how to use it. And so if you encounter a client in a divorce or in a situation unmarried with embryos, one of the first things to potentially do is seek an injunction to enjoin the fertility center from using any of the embryos without both parties' consent or a court order. Another protective order also to do that. I think it's also consider doing a motion for declaratory or summary judgment, especially if you're in the middle of a divorce, to try to get the decision on who gets the embryos to be resolved early on in the case. From a litigation strategy standpoint, I have often offered in writing to facilitate financially a person to go through IVF with a donated sperm. I think that certainly that's an interesting factor. If someone says, I don't want to go through IVF, I only want these embryos. Well, how are you going to show that they can't have babies through other means? And if they only want to use the embryos that exist, it may impact a court's decision in awarding the embryos. And then obviously having contracts like Dina drafts in advance so that you could do the declaratory or the summary judgment to say who's awarded them is valuable. I'm currently in litigation where we had to join a third party because I know that I can't remember what judge on the panel, but there's certainly a judge where I had an agreement on how to dispose of embryos. So I was involved and am involved in a case right now where we had an agreement on how to dispose embryos. And then afterwards, the fertility clinics require you to sign a disposition, a subsequent document, and that person refused to sign the disposition consent. And we had to add the fertility clinic to force them to comply with the agreed order and dispose of the embryos. So even where you have situations where people agree on how to dispose of the embryos, in effect, once they actually get to the place, they may not sign the contract, they may not sign the disposition, they may now no longer be compelled to comply. And so it's important to understand the different ways in which the court system can be used to help facilitate that resolution. And so with that, I think we have a couple examples of scenarios, hypo, so we can kind of talk through what this really looks like. And certainly if anybody has any questions, we're also open to that as well.
So, hi, I'm Judge Rosen, Lori Rosen, but, and I apologize, I logged on about a minute or two late, because I had crazy court stuff. Anyway, I just put the hypotheticals into the chat. So if you want to, you can download them, but I will read them out loud as well, because I think that makes things easy. And the hypotheticals that we came up with and that Molly drafted really tried to encompass all of these different scenarios that people may or may not occur. It's such an unknown field. So we tried to encompass everything so that we could pose questions to judges and give you an idea of how we might be looking at these situations and, you know, what our perspective would be. But the first hypothetical is we've got Noah Calhoun and Allie Hamilton, who met in North Carolina. Allie was visiting Noah's beachside town during a summer vacation. So I'm sure this is not a personal story, but the two quickly began dating. They knew they wanted to get married eventually. Allie wanted to finish college, and Noah wanted to continue building up his furniture business, being in North Carolina. So after Allie graduated, Noah proposed. They started to plan their wedding. In the midst of wedding planning, Allie was diagnosed with stomach cancer. So she had to have chemotherapy, radiation treatment. She was only 23. And prior to her diagnosis, she was in great health. So the doctors did warn her that although the cancer was located centrally, that there was a really good chance that it could negatively impact her fertility. And she had a great chance of recovery. So her doctor told her that they could utilize the chemotherapy with lower risks towards or of impacting the fertility, and because her cancer wasn't aggressive, there was a low risk, but it could still do damage. And they wanted her to be aware of that. So knowing that they had those risks and knowing that they were in the midst of planning a wedding and wanted to start a family and have children together, Noah and Allie agreed to create embryos prior to her undergoing her cancer treatment, just in case the impact was negative on her ability to have children. So they went to a clinic in Raleigh, North Carolina. That's where they were living. They engaged in IVF treatment there, and they signed multiple medical consent forms, including a form that asked Noah and Allie what should happen to the embryos if the two of them separated. So Allie checked the box next to the option that the embryos be allocated to her in that scenario. And she gave the completed paperwork to Noah. He signed it, but now claims he didn't read it in full. So the treatment was successful. They were able to extract 6 embryos. They were created, they were frozen for future use, and they were stored in the facility locally in North Carolina. Okay. Now, Allie then went through cancer treatment. It was successful. They wanted to have a fresh start. They move here to Chicago. She becomes a teacher at the Art Institute. They get married here after they move here. And when she was 25 and Noah was 27. During the marriage, they transferred an embryo after 2 failed transfers, and they ultimately had a healthy baby boy. So they had 1 child. They're married 7 years. Noah learns that Allie's having an affair with some old family friend, Lon Hammond. And, at a time they were going through a rough patch. So they decide to work on their marriage. And they also decided to enter into a written agreement. They found something online, they edited it together, and it dealt with certain property matters in case the marriage didn't work out. In that written agreement, they addressed the remaining 3 embryos, and they agreed to destroy them. They did not get any legal advice for the agreement. They only discussed it amongst themselves at home. And although it was a printed out and written agreement, they did not sign it. So 3 more years go by. They now decide to end the marriage. Noah files for divorce in Cook County. And as part of his petition for dissolution, he asks that the written agreement that was unsigned and entered later be found valid and enforceable so that the embryos are destroyed. Allie requested that the embryos be awarded to her pursuant to the medical consent form signed at the time that the embryos were created. So the conflict now is between these two, one assigned medical document and an unsigned written document created later. So I'm gonna pose some questions to our judges, Judge Rosenberg and Judge Weber. And what would your perspective be in regards to the written agreement and whether or not the written unsigned agreement entered later during their marriage, whether that should supersede the medical consent forms? Thoughts?
Jerry. Is there a way to pin me? Maybe I can pin myself. Oh, ooh,
I just figured it out. I think you're good.
we're pinned. Go ahead, Jerry.
You're good.
I tried to pin myself and then took her pin away. Am I going first?
Go ahead.
Oh, so we've got the two agreements and sorry, got distracted by the pinning. The question is whether the switch agreement would come to play, whether it would be the consent form for the unsigned written agreement that they essentially found, it sounds like online, correct?
Yes.
So it's interestingly enough, I have not had this issue arise, so I am really glad I got to hear the first part of the CLE. I have only had this issue come up in one or two occasions in an agreed prove up on the MSA, where when going through it, I see the parties agreed to the same agreement. One was they both agreed they were going to dispose, and I think one was going to be donated, but both parties were in agreement, so that made it easy. I haven't had this as a contested issue. So I think, especially given that there's not much law on it in Illinois yet, I think what I very much look at statutes first and case law. So first I'd look at the initial agreement, the initial consent form, since it sounds like Illinois allows those or considers those contracts. It was signed by both parties, even though one of the parties now claims he didn't really read it. But that allocated to Allie. But then you have this interesting issue that comes into play, the unsigned agreement. To me, it's not signed, so it looks like maybe at some point it was contemplated, but it was never signed by the parties. I think you can consider a number of factors in addition to that. Maybe they didn't go through with an agreement. What is the consideration? Because that's something I always am, would be concerned about if you're treating it kind of like a post-nup agreement. And also not having any attorneys involved. In that instance, I'd probably lean more towards the consent agreement that was initially entered into, signed by both parties. And then becomes a credibility issue. How credible is Noah that he truly didn't pay attention, but he still signed it. So that was his choice. It's still a contract.
I would agree with Jerry. I think that the signed version is probably more reliable, and because in Illinois, we can look at that under this fact pattern. Also, at the time they signed it, she had, I don't know if that changed, I don't remember, but her fertility was so unknown. It makes sense that that was the agreement. Obviously, if the second agreement was with attorneys, it was in the form of some kind of postnup or prenup, and it was well thought out. I would then possibly find that it overrides the first one, because the first one, obviously, especially what I learned today from Miss Levy, that they're done, or I think it was from Miss Melcher, I can't remember, that they're done so spur of the moment right in the facility. I would without attorneys, I would definitely give, if the attorneys existed, the second one more weight in this particular case. But
And have either, I know you mentioned this, Jerry, but have either of you guys addressed this situation at all? Or I know that you both handled something in this zone. So can you each talk a little bit about your individual situations?
So I've had a pre-trial where it was an issue. I want to say it was the Chicago, it was one of the big labs over on Chicago Avenue. I can't remember the name, but they had a very concrete contract. It really, they came in with the pretrial, both attorneys were pretty realistic that that's what the law was and that's what we had. I thought the direction they were going was to negotiate the embryos for another, for an asset, based on what I read in the pretrial, and I was ready to deal with that, but they never did. I think they came in, I said, here's the contract, the law says this, and it was not really a fight. It was sort of, you know, they just needed to hear it verbally.
Jerry, what about you?
Again, the only instance I've had it before me at this point, though, I feel confident we are going to have these issues, is in an agreed MSA. What I think is very interesting now with what happened in Alabama, what could be interesting is, will we have cases where the parties do agree to it, but then there is still a problem disposing of it? So let's say their agreement is to dispose or to transfer or to donate, whatever it is, probably an issue of disposal or transferring it. How is that impacted by the ruling in Alabama in that state? Because I'm just generally reading about this in the news. What I've seen is it has impacted people in other states because there are only a handful of large companies that keep embryos frozen, and those companies are concerned about liability. For me, having a background doing defense work, there was personal injury. That makes a lot of sense to me, because when you are representing a corporation that is a defendant, you are always looking at how is this going to impact us financially? What is our exposure here? And so I see why a lot of these companies have been very hesitant to do anything now that they have this case law.
So do you have any issues? Like, do either of you think that there's any problem with the medical consent forms themselves and the way that they are presented? Because it seems like, since there's not a lot of case law, that's what we're really going to be heavily relying on when things appear before us.
Should be treated almost given the same factors as determining whether or not you're going to enforce a prenup. And then, I mean, it seems like very similar factors. However, it would be best if it was required that they were tendered those documents a certain number of days ahead of time. So at least they have the option of getting an attorney, but you know, clearly there's nothing requiring that. So it's irrelevant what we think would be great.
I think the argument's going to be, for a lot of people, I was under duress to sign this, which makes so much sense to me, because especially as I'm learning for the first time today that they're basically handed it would almost be if you are handed a prenup to sign, you know, at the point of the wedding. And you've
Right.
got 300 people in the room. So kind of the same thing, my understanding of IVF, it's very time sensitive. There's a point where you have to retrieve, otherwise you miss that window. So I like Judge Weber's point that maybe giving those documents in advance, maybe giving the opportunity for at least an opportunity for an attorney to review. Whether you choose that or not is a different story.
I think I'd give more weight to the document if they actually hand wrote what their option was versus checking a box. I know it seems like such a minor detail, but if there was literally a space, here are the options, please write out what your choice is versus checking a box. I feel like, again, it's just it's minor, but it gives them a little more opportunity to think as they put the words onto the paper.
Judge Weber, this is Rebecca, I don't think it's minor at all, because the case that I litigated where the consent was not clear and there was some ambiguity, my client said they were in the small room, his wife checked it and then just said, sign right here. And we hear that all the time in divorce litigation. I didn't review the tax return. I didn't know. And he said, I didn't intend for this. I thought we were signing, yes, here's my sperm, take it. even an initialing next to every
That's what I was gonna say.
discarding, saying if you want to discard, if you want to donate, if you want to store, even having them initial next to it might remove each individual, might remove the lack of clarity, because the concern is, are they actually making an informed consent and decision about what to do?
Yeah, I know that a lot of times when you go to just any kind of a doctor and there's different things that you have to discuss, they have you initial each paragraph on its own. So even that seems like it would be better, but it also seems as if, and I have not experienced in this world, but that the clinics can be educated a little bit on how to better keep these people informed. I mean, it seems crazy that people aren't given forms with, the second they go in there and start discussing all of this, it seems like they should be provided the forms so that they can review them and look at them and talk about them so that they aren't put on the spot and they have time. Even if it's a form that everybody's given with the same options, that they can have that time to think about their choices so that they can't come back later and say, it was thrown in my face last minute.
I have to pick it out too, Judge Rosen, if you don't mind. I also think it's so interesting because one of the forms that we shared, it says, you have the right to seek psychological, medical, or legal advice. And if you have further questions, ask the staff. What? You want to ask, so you are guided to ask the medical staff about the legal implications of the contract that you're signing there. It blows my mind that there's not some legislation, there's not some form of doing it, that the American Medical Association hasn't put something out there, because I think it leaves uncertainty for everybody.
Yeah.
That is correct. I would say the same thing I hear all the time. Oh, I talked to my doctor about the disposition options and they were guiding me through it.
What I think is interesting, having seen some of these medical consent forms here today, is they remind me very much of forms you fill out if you were going to go to a trampoline park or,
Yeah.
field trip or something like that. And I'm sure there was probably some lawyer somewhere that generally created it, but it's all about how that is then handed to somebody and addressed. And it's
So I
so
want to get on to the second hypo in a second, but I want to ask one more question of the two of you in regards to this one, because I think it's interesting. How much weight would you give to whether or not she could have kids in the future, or actually either party was able to have kids in the future? If you're given an argument and that's one party's claim versus the others, how much weight do you give that versus where they are in their lives now and what they each want to do and move forward with in their lives currently, if they're have another spouse, partner, whatnot?
I mean, the fact that at the time she signed it, she didn't think or didn't know if she would be able to have her own biological child makes it more likely that they were meant for her no matter what, right? Because that was why they did it at the time. Again, they weren't married yet. I think whether or not one of them has the ability to have a biological child in the future is definitely a factor. I mean, do these people ever argue? I don't know, Miss Meltzer, Miss Wilson, or Miss Levy, if that they should each get one or divide up I hate to use the term split the baby, but do you know what I mean?
Absolutely. Absolutely. There's the idea that we was negotiating, there were 3, you take 1, I take 2, which graded do you take? Because again, as Dina mentioned, some pre-embryos are a better grade. So maybe you take the 2 worse and discard them, and you take 1 and try to inseminate it. I really think the argument for insemination and having one person is the strongest argument. So some of the cases in, CATS have looked into it, but also in other states, if you're looking to donate the sperm to another family, I don't know. I'm not a judge, but I'm having a hard time saying, okay, there's going to be a child out there with my genetic material because I've elected to donate it. Why are we doing that if we don't agree, right? There are people too who agree to keep them just frozen indefinitely. Let's put some funds, let's put in a trust. They are not comfortable for religious or other reasons getting rid of it, but they don't want to discard, even if it's a humane discarding of it. But yeah, people kind of split the baby, so to speak, but then have to also manage the consequences. Is someone going to be on the hook for child support? Is there parenting time? Are you awarded this embryo with your full ability? Are you carrying it? Is someone else? Are you awarded it only to inseminate it for you to have a baby, or can you award it and donate it to someone else? So I think you have to think about all of those multiple ways in which there could be the what ifs in agreeing on how to dispose of them if it's not, discarding them by agreement.
So that leads into the next hypo, and I know we only have a few minutes left, so I just wanna, it's quick, but I think this ties into it, is that if the testimony, the evidence, everything at trial supports a finding that the embryos should be destroyed, the court finds that the embryos should be disposed of. So you've got these 3 remaining embryos, but they're not in Chicago, right? They're in North Carolina. So the appellate court in North Carolina says, sorry, but the embryos have personhood, because there's this issue. Are the embryos people? Are they property? That has not been determined. No court case has addressed it. When we were talking about cases and whatnot yesterday, it sort of seems that nobody wants to define whether it's property, personhood, or whatnot, because it's all linked into way bigger pictures here too. So let's say the North Carolina court rules that and says they can't be disposed of, and then Allie refuses to sign any disposition consent form. So judges, how do you deal with it? You've got what dominates? Do you not worry about what North Carolina says and just says they're getting disposed of, and you rule on it here, and then they'll have to fight about it in North Carolina? Do you order her to sign the form? I mean, what are your thoughts about how you'd address that situation?
I mean, I think in this, with the facts of this case, the hard part is you have to think about jurisdiction and who you have jurisdiction over. And sometimes, we get these issues unrelated to this fact pattern, but I would treat it like any fact pattern. Sometimes, if there's third parties and somebody wants you to compel a third party to do something, the court doesn't necessarily have authority over that third party. So are you third partying the person in? I think in this instance, with the facts that I have, I could order Allie to sign the form. Maybe they're coming in on a petition for rule to show cause then. And, with the facts here, maybe that's the order, then she doesn't comply, then the purge is signing the consent form. I certainly think without adding the facility in North Carolina with the facts here, that I wouldn't have any authority to order the North Carolina facility to do something unless they were third partied into the case.
Andrew?
The only other way to get super creative, and again, I don't know what you would do upon death of the parties, is to order her to, or get them to agree that she would pay for indefinite storage if she really didn't want to sign it. But then again, we come up with the issue is what happens upon death. I don't know the answer to that. So I think I'd probably, unless they agreed to that option and came up with a solution as to what to do upon their death, I would probably order her to sign it and then bring her in on a rule. I mean, after that, there's not much to do.
So I know that Aaron had, I think we're ending at 1:15, correct? Yes, I believe so. So Aaron had put in the chat that if anyone has any questions, I don't see anything in the chat, but before we wrap up, if you do have any questions, you can throw them in there now. I wanted to thank Aaron for helping put this together, and definitely Rebecca Meltzer, Dina Levy, and Molly Carmody for drafting and creating the slides and presenting. You guys were great. And thank you to Judge Rosenberg and Judge Weber for your perspectives. My sort of final thoughts generally, because this is just this whole, even though that, we've been dealing with these things for years, even if those of us who are old enough remember the, oh my gosh, the baby case with the that was taken away. It was so horrible. It was all over the news when we were kids. But the Supreme Court took a child away who I believe it was a surrogate, and they took the child away from the adoptive parents, and it was Baby Richard. Thank you. Yes, the Baby Richard case. It's this assisted reproduction in some capacity has been going on for many, many years, but yet the case law is really, really sparse. And it's going to explode. It's going to be dealt with. And I think that the best options for practicing are to try and get your clients, and I know that you often get your clients later on down the road, but to the extent that you can, get them to plan and think ahead and prepare for and address all of these issues to the most extent that they can in their documentation before things happen. Because when they can, and it's emotional and it's so hard, and it's certainly understandable why people don't want to address some of these things when they're dealing with signing these medical consent forms, because they're so overwhelmed by the idea of what they're undertaking. But their best option is to think about these things and address them and get it down in writing and agreement, so that later on down the line, they don't have to be worried and stressed and argue and not know what court's going to rule what and where, and what the law will be wherever that court who has jurisdiction can rule. I mean, those things are all of issue and on the table. And to the extent that they can, plan, prepare, and deal with it as early on in the process as possible. Those are my thoughts on how to handle at this point all of these different types of issues. Any last words from any of the attorneys or judges?
We do have a question in the chat.
This question just came in. It says, if there is a conflict presented to the attorney when the couple first comes in for counseling because of all the issues that could happen.
I'm not sure what the question is, but I sort of think I inadvertently addressed it right now, right? Try to get them to work out an agreement. I mean, even if they're a lovely, healthy, happy couple and they still can't reach an agreement on some of these issues, going and seeking counseling, I think is what needs to happen to help them work through it. I don't know what else can help them reach some sort of a resolution, but delaying that resolution is not going to be productive. So to the extent that they can go seek counseling, seek help, maybe if they're religious, a religious person can help them. Seek counseling to the extent that they can from an outside person, I think, to help resolve as early on in the process as possible. I think that's.
I'm wondering whether Mark was talking about the conflict for the attorney, that if afterwards the couple disagree, is the attorney who handled the arrangements, is this the attorney for one of the people, or are they conflicted out and can't participate, and each of the couple have to get a new attorney?
Gina and Rebecca?
I don't think you could represent somebody in the enforcement of a contract that you drafted on behalf of both of them. I think that's absolutely a conflict of interest, especially if there's anything about their intent. You need to testify about any of the things leading up to it, if it's ambiguous. And even if it wasn't, I don't know the rules enough sitting here thinking about it, I would never take it. I don't think it looks good. But it does absolutely seem like a conflict of interest.
I completely agree.
And there are times where I think that actually both parties should have their own lawyer, right? There's oftentimes where the subject matter, when you're managing this, it is important for them to each get their own guidance.
Like in a prenup.
Correct. And a prenup doesn't require two lawyers. I know I require, if I'm doing a prenup, the other party have a lawyer. So sometimes that's just best practices rather than a formal conflict under the rules of a professional responsibility.
And then one other question came in. Do regular principles of contract law apply to embryos as joint property unless contracted otherwise? Or are there special considerations that apply to them uniquely?
I think Safransky and Katzip address that it is a contract law. If there is a contract, that can be an oral contract like I had in Safransky, or there can be a written contract, which the courts acknowledge that these medical consents can be written contracts. When there's not a contract, whether oral or written, is when they look to the balancing factors. But not in Illinois. There hasn't been an Illinois case that says it's marital property subject to division. Unlike another state, Alabama, but I think that we're going down that route where it's maybe this sort of unique form of some sort of property hybrid, but I'm not sure that we're at a place where we would say it's property, but it's certainly divisible, I think, as kind of an asset. That's how I manage it in a divorce case.
Part of the problem is the definition of whether it's property or something
Yeah.
else.
Yeah, or special property.
Right. Well, thank you very, very much. We appreciate everybody's attendance and hope that everybody learned something.
Hey, and we do have an evaluation poll that I'm going to put up right now and ask the participants to please complete it and ask the co-host not to touch it because that turns it off and then no one can do it. But we'll share that with you. And I'm going to just talk on a little bit more, although since we do have some time left, if people have questions, feel free to post them in there. But I just want to remind everyone about our upcoming CLEs, which you can find on the CLE page of our website. And on April 17th, we have a class that had been postponed from a previous date. That's ADR and the new regulations. On May 2nd, another class that was postponed from a previous date, and that's the new rules on retainers and client trust funds. Then we have a special CLE on May 9th, defining hate speech, when does speech cross the line? And this will be the first CLE we've done since the pandemic that there's going to be an in-person option. It will be a hybrid, but there will be limited seating at Hinshaw Culberson, who is hosting us. So if you're interested, definitely, of course, sign up for the class. If you're interested in being in person, sign up early because those seats will fill up, and we will be offering a light lunch before the class for the in-person attendees. Then on May 23rd, we have the Wendy Muchman Professional Responsibility Lecture Series, which is always a big fave. And of course, we will get ethics credit for that. Then on May 30th, we have a class about benefit corporations. And then and registration for all of those is now open on our website. On June 6th is the last CLE of this bar year. And that is another special CLE, and that's media during wartime with a speaker from Ben Gurion University. And registration for that will open either later this month or first thing in May. Then also please visit our current events page. We have our model Seder coming up on April 11th at the Holocaust Museum. And there will also be the opportunity, if you have not yet seen it, to visit the exhibit of I'll Have What She's Having, the Jewish deli in America. And I also want to say I know we have some non-members here today. Right now, there is a membership special that if you join now, you will get membership not only for the rest of this bar year through June 30th, but for an entire year afterwards. And if you've come to any classes that you've not gotten credit for since January, we'll give you retroactive credit too. And you can find the information for that on our membership webpage. So again, thank you for a wonderful presentation. Thank you to our presenters. Thank you to Erin, and I think there were other members of our women's committee who helped put this together. And I think that is it. If anyone has anything else that they want to say, and I also will allow people to unmute themselves if you want to talk amongst each other. I think if there's no other questions, I'm going to end the recording. Last call for questions. Okay.